ये क्या मैटर है बताइए।
Millet, I am the petitioner in this matter, Millet. I am aggrieved by annexure P1 and P2, wherein Commissioner on second appeal has allowed the same and directed that revenue records be mutated in a certain manner. Millet, preceding these particular orders, there was a civil suit which was filed by me seeking declaration and partition. That traveled all the way to the Honorable Supreme Court, Millet. Initially,
गोपाल सिंह रघुवंशी जो है,
my lord,
इनकी वसीयत के निर्वसीयत मृत्यु हुई है कि वसीयत छोड़ के गए हैं?
intestate, Millet. Intestate.
तो फिर आपको शेयर नहीं मिला है उसमें क्या संपत्ति में?
Millet, the Honorable Supreme Court has
आपकी
directed
जो प्रतिवादी है वो आपकी माँ और बहन है?
a stepmother and stepsister, Millet.
हाँ, स्टेप मदर एंड स्टेप सिस्टर।
My lord.
तो उनका क्या हिंदू लॉ में क्या प्रावधान है? उनको
मतलब
शेयर मिलेगा कि नहीं?
Section 8 says 1/3 they are entitled to, and I am agreeable to that. Today, what they are doing, Millet, is that they are saying that the property in dispute is beyond what was the self-acquired share of my father, and it is including my self-acquired properties also, and that is what the commissioner has directed, Millet.
पढ़िए सेक्शन 8 पढ़िएगा हिंदू
My
सेक्शन
lord.
क्या कहता है?
Video conference.
Millet, Section 8 of Hindu
वीडियो
section.
कॉन्फ्रेंस से क्या हो गया?
Mr. Singh is also on respond number 7.
Huh.
He is joining in video conference. And she is junior.
Yes. जी
Millet, Section 8 says general rules of succession in case of males. The property of a male Hindu dying intestate shall devolve according to the provisions of this chapter. A. Firstly, upon the heirs being the relatives specified in Class 1 of the schedule. Now, Class 1, Millet, admittedly provides for a son, a daughter, and a widow.
बताइए शेड्यूल में पढ़िएगा, शेड्यूल कहाँ है?
Millet, schedule is at the end of the enactment, Millet.
उसमें देखें, उसमें second wife is not included. Actually, one of the wife will be second wife.
Millet, I am not disputing that.
नहीं, एक सेकंड,
My lord.
आपने कहा ना 1/3 शेयर,
My lord.
इसलिए मैं समझना चाहता हूँ 1/3 दोनों को मिलेगा ना, वाइफ को और डॉटर को।
My lord.
1/3 आपका होगा,
My lord.
उनके पास 2/6 चला जाएगा ना।
My lord.
जी
2/3.
2/3 उनका हो जाएगा।
Millet. The difficulty in the present case is, Millet, total property is 38 acres around.
Yes.
During the pendency of the litigation, my father and my stepmother have already sold 20.66 acres of the property.
Your father sold it ना?
My father has sold it along with my stepmother.
ठीक है,
My lord.
whatever it is.
My lord.
The property was in the name of your father or your grandfather?
My father.
Your father.
My lord.
So he was free to sell it. Now
Certainly, my lord.
20.66 has been sold
My lord.
out of 38.
My lord.
So remaining is about 17 point some
My lord.
acres.
My lord.
That will be devolved in the ratio of 1/3. Can you?
My lord, my humble submission is that the entire controversy is governed by the order of the Honorable Supreme Court.
जी,
My lord, that is at annexure P5,
जी,
and it starts at page number 49.
yes.
The operative part, my lord, starts at page number 4, last line.
ऊपर से पढ़ते हैं ना, समझ तो नहीं।
My lord.
Yes.
My lord. My lord, so what the Honorable Supreme Court decided is that whatever I had claimed in partition, they said everyone's share became their
First
self-acquired
thing
property.
they held that it was not an HUF property. Second thing which they held that the application under order 41 rule 27 should have been allowed, and they allowed
lord.
bringing the partition on record.
My lord.
Now the issue is that once it was not an HUF property,
My lord.
it was property of Gopal Singh.
My lord.
Now how it will devolve? Whatever was sold by Gopal Singh during his lifetime,
My lord.
the remainder is to be devolved amongst his 3 successors, or that account of the previous selling of
My
the
lord.
property is to be taken into consideration. That is the only legal issue involved in this
My
case. बताइए उसके
My lord,
ऊपर
the
से।
doctrine of lis pendens will come into the
नहीं,
picture,
नहीं,
my lord.
not list pendants,
Hmm.
because the thing is that this property, your right will accrue as a legal heir only upon death of Gopal Singh Raghuvanshi.
My lord.
During his lifetime, you had no right in the property of Gopal Singh Raghuvanshi. And if Gopal Singh Raghuvanshi sold some property during his lifetime, then that cannot be claimed by you. You cannot claim a share in that property which was already sold.
My lord, my humble contention is,
नहीं, लीगल बात करें, humble
My lord.
contention से कुछ नहीं होगा.
my lord,
अपना लीगल इशू बहुत क्लियर है कि आप तीनों लोग, उनकी पत्नी, द्वितीय पत्नी, उनकी स्टेप डॉटर और उनके मूल पुत्र, इन तीनों के बीच में जो संपत्ति बची है वह उसमें पार्टीशन होगा सेक्शन 8 के मुताबिक, या पूरी संपत्ति में से आपका कंटेंशन ये है कि वो क्योंकि 20 एकड़ बेच चुके थे 31.10 में से, तो जो 11 बची वो आपकी पूरी आपकी है, यही कहना चाह रहे हैं ना आप?
My lord,
क्योंकि वो 20 बेच के आपकी अपनी पत्नी को और पुत्री को जो है साथ दे चुके थे.
my lord,
दिस इज व्हाट यू वांट टू से.
my lord,
बताइएगा, लॉ बताइए आप. नाउ फैक्ट्स आर क्लियर.
my lord. My lord, my contention is that the order of the Honorable Supreme Court holds in categoric terms that pursuant to registered partition deed, the share which Gopal got became his self-acquired property, and the Honorable Supreme Court has held that in that share, I am entitled to a
But Supreme Court, this litigation was not before the Supreme Court, that if Gopal Singh happened to sell some property during his lifetime, that will also be treated to be the property which devolved in favor of his wife and daughter.
well, that's the issue of material suppression because this fact was never brought on record before the
You-
Honorable
you-
Supreme
you
Court.
should have approached Supreme Court for clarification. You were a party before that court. Now, as I understand, and my understanding goes that whatever was left on death of Gopal Singh Raghuvanshi, that is to be devolved amongst his legal heirs in terms of the provisions contained in section 8 and the schedule appended to the Hindu Succession Act.
My
This is
lord.
my understanding.
Will it, my submission would be that only, will it?
I'll record your submission and then
Well,
discard it. लिखिएगा. This petition is filed
Will it, if I may
by
clarify one
Rajesh
aspect?
Kumar Raghuvanshi,
My lord.
being son of late Gopal Singh Raghuvanshi, canvassing himself to be a lawyer by profession, being aggrieved of the order dated 9th November 2021, passed Annexure P1, passed by learned Additional Commissioner, Bhopal Division, Bhopal, and Bhopal Division, Bhopal, on the ground that second appeal was not maintainable in the hands of the Additional Commissioner. Next pair. Shri Utkarsh Sonkar, learned counsel appearing for the petitioner, submits that the whole controversy is settled by the Honorable Supreme Court while deciding civil appeal number 8428 of 2009, while its order dated 8th
13/8/2014.
August 2014. Full stop. Next pair. Brief facts of the case are that in partition, Gopal Singh Raghuvanshi had received 31.10 acres of land. Full stop. This partition deed was dated 1/6/1971. हाँ बोली क्या?
Well, a clarification is it's actually not 31.10, it's 38.13 as is written in the partition deed.
Maybe, but the Supreme Court कह रहा है, I have no authority to supersede the orders of the Supreme Court. Again, you are required to approach the Supreme Court. At this stage, Shri Utkarsh Sonkar submits that it is in fact not 31.10, but as per the partition deed, it is
8.13 acres.
38.13 acres. Full stop. Next para. Petitioner's contention is that since Gopal Singh Raghuvanshi sold about
0.66 acres.
20.66 acres of land during his lifetime, therefore, he had already sold 1/3 or 2/3 of the land vested in him during his lifetime, and that being the share of wife of Gopal Singh Raghuvanshi, namely Srimati Nirmala Raghuvanshi, and his stepdaughter, namely Kumari Madhumita Raghuvanshi, comma, now as per the Hindu Succession Act, remaining land should devolve in his favor as he is entitled to 1/3 share in the property of Gopal Singh Raghuvanshi, who admittedly died intestate. Full stop. Next pair. Shri, आपका शुभ नाम बताइए.
Hemant Namdev for response number 6 and 7.
Shri Hemant Namdev for respondent number 6 and 7 submits that the property which is to be devolved is the one which remains after, on the date of the death of Gopal Singh Raghuvanshi, and that property is to be devolved in terms of the provisions contained in Section 8 of the Hindu Succession Act 1956. Full stop. Next paragraph. After hearing learned counsel for the parties and going through the record, comma, Supreme Court, by its order dated 13/8/2014, was dealing with two aspects. One, whether the courts below were justified in rejecting an application under Order 41, Rule 27, refraining to take on record a partition deed dated 1/6/1971. Full stop. It also dealt with another important issue as to whether the property was HUF property or it is to be claimed to be the property of Gopal Singh Raghuvanshi. Full stop. Answering these aspects, it firstly held that the property which was received by Gopal Singh Raghuvanshi on account of partition deed dated 1/6/1971 will be treated as his self-acquired property and not as HUF property. Full stop. It further held that the courts below erred in dismissing an application under Order 41, Rule 27 CPC and directed for taking the said partition deed on record. Next paragraph. Thus, two things are crystal clear from the aforesaid judgment of Supreme Court dated 13/8/2014 that the total land, be it 31.10 or 38.13 acres, that was treated to be the independent property of Gopal Singh Raghuvanshi. Next paragraph. We are concerned with the aspect that whether the property which stood in the name of Gopal Singh Raghuvanshi during his lifetime is to be taken into computation for the purpose of succession, or the property which remained on the date of death of Gopal Singh Raghuvanshi will be the subject matter of devolution of estate in the hands of the successors. Full stop. Question mark. To answer this question, comma, Section 8 of the Hindu Succession Act is relevant, which says the property of a male Hindu dying intestate shall devolve according to the provisions of this chapter. Full stop. In the present case, the property which is to be seen is the property which remained at the time of death of Gopal Singh Raghuvanshi. Full stop. Next paragraph. Thus, this court is of the opinion that if any property was sold by Gopal Singh Raghuvanshi during his lifetime, then it will not be treated to be part of the estate which was left behind by him at the time of his death. Full stop. The property which was left behind can only be treated to be the estate of Gopal Singh Raghuvanshi, and as per Section 8, the remainder of estate which was existing at the time of death of Gopal Singh Raghuvanshi is to be divided in applying the principles of succession as are mentioned in Section 8 of the Hindu Succession Act 1956. Therefore, when tested, then petitioners claim that he is entitled to the remainder of estate of Gopal Singh Raghuvanshi, as he had almost sold 2/3 of the share during his lifetime, and which will be deemed to have been utilized for the benefit of respondent number 5 and 6.
6 and 7.
6 and 7 cannot be accepted. Full stop. Thus, when tested on this touchstone, then this court has no hesitation to hold that firstly, petitioner is entitled only to 1/3 of the remainder of the property which existed on the date of death of Gopal Singh Raghuvanshi.
As his self-acquired property.
So, ऊपर Supreme Court कह चुका, there is no need for
Milord,
prolonged clarification.
Milord, the issue has come up because of Commissioner's order. He has extended the property to make it 75 acres. That is the difficulty.
Full stop. As Supreme Court has already held, this property will be correlatable to the partition deed dated 1/6/1971. That is, whatever was received by Gopal Singh Raghuvanshi in terms of the partition deed dated 1/6/71 will be treated to be his self-acquired share, and out of this, whatever was sold by him during his lifetime is not to be accounted for the purpose of succession, and only the remainder property shall be subject matter of succession amongst the legal heirs of deceased Gopal Singh Raghuvanshi, namely the petitioner and respondent number 6 and 7 on the other hand. They all will be entitled to 1/3 share each in the remainder of estate. With the aforesaid modification, in the impugned order, petition is allowed and disposed of.